and I'm the founder of Art for Elephants, and I just want to provide a quick moment of clarity. In the program, it says I'm a law student, which makes me look incredibly impressive, but I want to provide a little clarity in that I took a semester class in law about 15 years ago, which essentially means that I'm completely terrified of liability and incredibly opinionated. So that's my thing about law. But I mean, I think we all know in this room that if we're going to make substantial changes, being a litigious society, we have to change the way that we look at animals in the eye of the law. And I'm so honored to be with these people, the panelists today, who are on the forefront of that, of creating real change through legal means and through all sorts of means, right? To get these elephants, to get the status of animals changed in our society, and I think that is a real critical first step. So that being said, I believe each panelist has 1 minute, and I don't want to introduce them. I want them to each do themselves. So let's just start and go down the table, okay? So you can say in your own words, and the first one is Eva.
Good morning. My name is... It's not on. Good morning. My name is Eva Chinoda. I'm from Zimbabwe. I've worked with the Zimbabwe Parks and Wildlife Management Authority for 3 years. And I'm also the founder of Speak Out for Animals, which is a new organization that I started whilst I was doing my master's in animal law with Lewis and Clark Law School. I'm currently here in Portland for a few months, and I'll be going back to Zimbabwe to continue with my job and looking after the animals. Thank you.
My name is David Casselman. I'm a trial lawyer in Los Angeles. My day job is civil litigation, and my passion is pro bono animal work. Been doing it for about 30 years now. I've litigated and fought over animals of pretty much every size and shape, and elephants have become a focal point in part because of the LA Zoo litigation, and also because of my involvement in the Cambodia Wildlife Sanctuary, which I co-founded about 15 years ago, and working with Lek and later Ashley Bell, who came across, led to the Love and Bananas movie, which we're screening here tonight. So those are some of the things I'm very excited about.
You guys, everybody speak really loud into the microphone.
Okay, good morning. I'm Lisa Kane. I practiced law for 31 years and then happily retired from that. My advice is, when possible, stay out of court. It really is the last act of desperation when you're trying to help elephants anyway. It's certainly been my experience that the courts are not particularly sympathetic to the plight elephants find themselves in here in the United States. I did, however, write a law review article about CITES and addressing the question of whether or not zoos' exhibition of elephants is primarily a commercial activity. Because if the answer to that question is yes, then CITES would prohibit the importation of elephants from Africa or Asia to our zoos. The question, sadly, has not yet been squarely addressed by the courts, but if and when it is, I hope that counsel for the animal protection side of the table will be armed with the arguments in my law review article and give them a fair hearing. So that's my story, and now I'll pass it on to Julie.
Hi, so I'm the really loud one. Who knew? I think it has something to do with this mic. So my name is Julie Woodger. I'm the only non-lawyer on this panel, which hopefully gives me some kind of a unique perspective on it. I'm the one that takes advantage of these people's time to figure out what kind of actions might be taken on behalf of animals. We've done several legal actions for animals, and we are, of course, currently engaged in one for Lucy, the elephant at the Edmonton Valley Zoo, which has been a long legal fight and a challenge. And one piece of advice I would offer right off the top is I think legal challenges should be the absolute last line of resistance on your campaign. There's lots of other good ways to win campaigns. You know, for instance, the Toronto Zoo elephants, we got out and sent down to pause, and that was really doing private meetings with the people who had control months, a year in advance before it ever became an issue. So to me, legal initiatives are the last line of defense, primarily because they're the most difficult to achieve because of the court system.
Hi, I'm Delcy.
Oh, sorry, Julie. Do you want the loud one?
I think this will be okay. I'm Delcy Winders. I am Vice President and Deputy General Counsel for Captive Animal Law Enforcement at the PETA Foundation, and I also teach animal law currently at Pace Law School. And my team at the PETA Foundation is comprised of lawyers, scientists, and veterinarians, and we advocate for animals exploited, wild animals exploited for entertainment, especially in circuses and roadside zoos through the legal system. I've been working on elephant issues for about 15 years now. I think the first case I worked on was Tina and Jules' case. I've also worked on the Hawthorne elephants case, Ringling Brothers, Nosey's case most recently. And I think the most important thing I would say, and I think it ties into things that others have said, is that it's really critical that your legal effort be part of an overarching, multi-pronged approach, that you're not just filing a lawsuit. And then related to that is often you will lose your litigation, but ultimately win the battle. And we saw that with the Hawthorne elephants case, as well as with Ringling Brothers. So.
Thank you very much. So without wasting a lot of time here, let's start with the questions. And there's some good questions here. So I like this one because it's positive. So let's get a positive start. And I'm going to open this up. You can volunteer, you guys, because they're not specific. So can you comment on a standing hurdle you have encountered and have been successful in overcoming? And Ava, why don't you take that one first? Something that you overcame. You don't have to. I mean, you could pass it on.
Okay, I can pass it in.
Yeah, pass it on. Whoever wants to take
ahead,
that. David.
You know, I think this one has a volume.
This one's
Can you hear?
loud.
Can you hear? Okay, or? Okay. The.
Can we get a louder one?
This one's super loud.
Can you hear? Yeah. Wow. Yes, it is. The initial success, I guess you have to define success for me because we had a great deal of success in LA. The presentation I'm going to make a little later talks about things that happened after our success, but the trial itself involved the use of a taxpayer waste statute where we convinced the court and the trial court and the Court of Appeal on 2 occasions that taxpayers have a right to challenge government action that violates, in that case, animal cruelty laws. The Supreme Court ultimately reversed it, and so we didn't have ultimate success. We are about to probably pursue other avenues. There are other ways to get standing. The problem is each remedy is tied to the wrong and to the nature of the claim and the people who bring it. So we're thinking carefully now about how best to go back at the problem again to get the elephants out of the zoo or to change the behavior of the zoo. And standing is always the #1 hurdle in almost every animal case.
I'll jump in and add to that. I think people generally think of standing in animal cases as turning on aesthetic injury to an individual who knows and who has seen the animal, and that's critically important. But equally important is standing for an organization that's doing work on behalf of an animal, and that's referred to as Havens Realty standing under the leading Supreme Court case. And it's interesting, I always teach my students that class, but it's not typically taught in animal law cases. And I would say it's just as important, if not more important, than the aesthetic injury line of standing cases for our work at PETA. And we've brought a number of Endangered Species Act cases. We recently got a temporary injunction precluding a roadside zoo from declawing big cats, for example, and we've gone on that standing basis.
So sometime in 2012, my first encounter was working with the Parks and Wildlife Management Authority. The rangers, one of the rangers in a certain village shot a poacher who was running away from the ranger. So in Zimbabwe, we have a shoot to kill policy. if you come across a ranger who's armed, the rangers are allowed to kill the poacher. But then, of course, I mean, shooting to kill is a last resort. You can't shoot someone who is not, I mean, a threat and immediate danger to you. So I was just like a year old from school, and I was the first and the only legal officer there, and I really didn't know what to do. And this case happened. So we went to the rural area and we did the indications, got information on what had happened, and obviously there was a problem to invoke the Indemnity Act in such a situation. So this ranger named Boa was sentenced to death, and we tried to invoke, and it didn't work because the argument was that the ranger was trigger happy. So we then appealed, and then he was then sentenced to 9 years. And after 3 years, he was sentenced to 9 years. And then last year, in 2017, the case went back into court after the court considering how poaching has become a problem, and he was released.
Okay, so this is a good question that I'm interested in. So, laws and measures sharply focused on the welfare of elephants are probably more often than not thwarted or clipped by financial considerations and big money forces. What are some tactics compassionate community can take on to circumnavigate big money organization and motivations? So yeah, this is a really good question.
Could you be more general?
Well, I mean, for example, when you're talking about with the success with Nosy, I mean, obviously there was some big money allied against Nosy, against releasing her. The libels had a lot of balls in their court and a lot of resources to draw on. How were you able to, you know, counteract that? Counteract these big interests in continued elephant exploitation?
I'm not sure Nosy is the best example of that because, frankly, the labels are not that well resourced. Also, I mean, it was local authorities. It was a compassionate local prosecutor and a local animal control officer who stepped in and made that happen. And that just doesn't happen all the time. But it does speak to the importance of trying to build relationships in your local community. And I think when you are working on an effort like that, that's a critical piece of it, including with your local legislatures. I think we've seen the most progress for animals lately and for elephants specifically at the local level. And so I think building those relationships are going to help overcome the big moneyed interests and those pressures, because people care about animals and people really care about elephants.
I just want to say too that using the legal system, after the success in Madison getting its elephant exhibit closed and its 2 elephants removed, about 5 years later the Dane County Board adopted a county ordinance prohibiting the presence of elephants in Dane County. So even if the zoo had changed its mind and had decided they were going to go back into the elephant business, they would be forestalled. So there are a lot of ways that you can create, you know, bulwarks against the kind of thing, you know, that you're trying to get rid of, like the exhibition of captive elephants. And that's you know, that's the seat of the state capitol. And also the University of Wisconsin. So I mean, there were a lot of very well-educated, sophisticated people who supported that and worked hard with the board supervisors to get them to sign on to that and vote for it.
Thank you. One thing I want to touch on real briefly is that my friend coined a phrase that I love called relentless incrementalism. And I think that that is one of the most important things for all of us to realize, that there's no magic wand here, and it's a series of little tiny steps, way more than there should be, and they take way longer than they do, but that doesn't mean we shouldn't make them. Okay, this one.
If I can jump in on that point, because it was mentioned earlier that it's important that we work together. And as a person trying to galvanize parts of the animal community, it's often the case that there is the passionate side that wants immediate progress and incremental change is not good enough, and the side that is willing to make progress and let go of perfection for the time. That schism often keeps the animal community from becoming a galvanized force, increasing its chances of doing so much more. And so putting progress over perfection is, I think, a critical piece of that. Knowing what the opposition is doing and how they're doing it is very important. Knowing who can make the change for you and what they see, what they perceive to be the benefit of what they're doing, understanding that and working with them in their mind, helping them affect change that's positive is the easiest way. Always working from their vantage point is easier. It's not often possible because, as the phrase big moneyed interest, you're talking about people being paid, and you can't just outbid big money. So it's tricky. Very difficult. There's more failures than successes, and that's why you have to be satisfied with, you know, one win out of maybe a lot of failures. Just keep trying.
Wasn't it Winston Churchill who said that the hallmark of success is to go from failure to failure with no loss of enthusiasm, right? Okay, so this is a good one. How do you make the decision of when to take the legislative route versus litigation? You want to take it, Delcy?
Julie. I'm sorry, Julie.
No problem. So, of course, this is what we do all the time, right? We always start with trying to influence the people who have control over to make the decisions very privately, before it gets into a council chamber, before it gets into the media, all of that, because what we know is that people who make those decisions make them long before they end up in a decision-making situation. That's first and foremost. So your campaign should always start in a private setting, in my opinion. And then once you're sure you have the votes, then you initiate the legislative side of things because you've already got the votes. Some of the votes you'll lose, but you'll win some on the other side as well in that process. So for us, for instance, when we got the Toronto elephants out, that's how we did it. We did it all privately behind the scenes. In the case of Lucy, and this perhaps goes back to the last question as well, that is an interesting situation. Of course, we went through all of those steps. We attempted legislation. We even got in good legislation in the province of Alberta, but like most laws in Canada, you know, enforcement of laws is discretionary. And the zoo is arguing that she's too sick to be moved. And we, of course, have no control over the animal. Again, big business, they always own the animals. We have no access to them to do our own assessment or even to necessarily get in the proper experts to do it. And we just ran into a brand new stumbling block that I hadn't anticipated, and that is now the government is arguing that the welfare sections of the law are not enforceable in law. So I'll tell you, I'm darn happy that we also put in significant public safety issues, and I want to warn everybody about that. I know some activists feel like it's disingenuous not to argue what we really feel in our heart, which is, you know, the welfare issues associated. But in my experience, you win far more often on the public safety issues, and courts are far more likely to intervene if they think that people are at risk than individual animals being at risk. It's a sad truth, but it is the truth.
I'll jump in on that also. I think, I mean, as Julie suggested, it's a much bigger question than legislation versus litigation, and there are a lot of things that should come before either of those probably. I think that the bottom line when you are looking just at legislation versus litigation is you can't really bring litigation unless there's legislation in place or some law, some cause of action to get you into court. So that's going to be a key determinative factor. If you don't have a law to enforce, you need to start with getting a law passed. Other factors that go into that consideration are just the many litigation hurdles that we face. We talked about standing a little bit already. A huge one is the fact that for the most part, you can't challenge an agency's or a prosecutor's enforcement decisions. So that limits your litigation options. Like I said, you need to have a cause of action. And litigation is very resource intensive, so it can be a great way of helping an individual animal or a group of animals, but when I'm looking at what lawsuits I want to bring, I'm trying to ensure that in addition to helping those animals, I am bringing impact litigation that's going to set some precedent that changes policy across the board for other animals as well, so that's a factor that goes in as well.
Yeah, absolutely, and I think we were all in agreement. You start privately, then you go to legislation. Failing legislation, you may go to litigation, and if the litigation fails, you may go back to legislation. But like Edison said when they asked him about inventing the light bulb, and they said you failed 999 times, how does it feel that you finally succeeded to get the light bulb? He said, I didn't fail 999 times. It was a 1,000-step process. And I think you have to keep that perspective.
Okay. Are you, and whoever wants this one, are you encouraged by the possibilities of using the ESA and state cruelty laws for the basis of both federal and state lawsuits? And I'm not familiar with what the ESA is. See, that's that one law class. Totally failing me right now.
I'll take it because I've done a number of these cases. The ESA is the Endangered Species Act, and
yeah, that's a good one.
and it's always been the case that it applies both to captive animals and their wild counterparts. And the Ringling Brothers case was the first lawsuit brought on behalf of captive wild animals under the Endangered Species Act. And part of the reason that's such a useful tool is that it has a citizen suit provision, unlike the Animal Welfare Act and other animal protection statutes, including state cruelty statutes. So I'm going to set those aside. I'm not that optimistic about them. There's a huge amount of potential with the ESA. We've been able to get a lot of animals out of bad situations and end a number of harmful practices. I also think we need to be really careful because this is an area of the law where we're establishing precedent right now, and it's very risky. Every decision that comes down is going to have broad implications for other animals in the future. This is a statute that's also under tremendous attack in Congress, and there are numerous bills to gut the ESA, including to make it not protect any foreign species whatsoever. So no elephants, no lions, no tigers, and those have made it out of committee. So they're real threats that we need to be attentive to, and so we need to attend to that as well as in making our strategic litigation decisions. And legislative backlash is always something that you should be thinking about in making a litigation plan, and that's especially the case with the ESA right now.
Yeah, again, I totally agree that the case in Iowa recently with essentially a roadside zoo was successful in many respects, involving what most of you would call cruelty-related issues, just poor care, terrible condition. But, for example, it did not succeed on what I would call an important precedent issue having to do with the size of the space, the enclosures, which is the kind of overarching issue that Delcy's talking about. And I am contemplating going back to court again if the legislative approach doesn't work in California for the LA Zoo with the ESA. And I'm worried about that very point, making bad law on an issue involving space, which is such a critical issue in LA. So these are delicate things to consider, especially in an evolving area, and something like LA could have so much public effect that if the Trump administration is still in power, it could actually push them over the top, and who knows what they would do. So those are all the kind of things you have to worry about, and state laws are generally not all that attractive because, as again Delcy said, they can't get at them. Standing issues are large. ESA has broad standing rights that are more easily accessible, but the remedy is difficult in many cases. So it is a delicate balance, and you have to be thoughtful.
Thank you. Okay, how can we promote zoo accreditations for non-accredited zoos? Minimum of 3 elephants. Non-accredited zoos can get away with having a single elephant for decades in solitary confinement. Is there a legal avenue to make a change? I think there's a little trepidation about promoting any zoo accreditation in this body, in this room. So.
I'll throw some thoughts out on this question. I mean, one thing would be for the accredited zoos to start following the policies, because they're not even all following the policies, so.
And USDA doesn't enforce them anyway.
Right. I mean, that would be something that in a normal world would be addressed under the Animal Welfare Act. The USDA does an abysmal job, which I would be happy to talk to you about all day long, and has been a focus of my work over the last several years, but I don't think there's really any potential there right now. I think we do need to look at mechanisms like the Endangered Species Act, but again, being very careful in choosing the right case and litigating it vigorously.
Personally, as someone who works on zoo issues exclusively, I would warn everyone to stay away from the zoo associations. They believe that going after any zoo is the thin edge of the wedge. They oppose good things. Of course, as many of you probably know, they heavily oppose the transport of elephants from the Toronto Zoo, which is an AZA accredited facility, to the Paws Sanctuary, and they fought it with everything they had, including removing accreditation from the zoo, which they later gave back because it was just symbolic. But it was a shot across the bow to say, look, anybody who's going to try to do anything that moves animals to a sanctuary setting is going to be opposed by our organization. So personally, do not trust the zoo industry. They are the problem. They are the enemy.
I have to, sorry, I just want to jump in briefly, and I think in the elephant context, it's tricky. Elephants are such a political issue in the zoo industry here in the US, but I would be remiss in not acknowledging that in a number of our ESA cases on behalf of lions and tigers, particularly some of our cases on behalf of bears, some individual members from the zoo industry have served as experts in our litigation, have helped with getting animals to sanctuary. So I think there is perhaps some opportunity there. I don't think the elephant arena is where we're going to find that anytime soon, but I think there's something there.
Associations.
Right.
It's the individuals.
Right.
So yes, there may be some good individuals in the industry, but the industry itself is the problem.
Yeah.
Can you reiterate that on the mic? I'm sorry. All I was just saying is Delcy and I work a lot together, so, but I don't disagree with her. There are some good people in industry, but the industry itself, in that these industry associations are a significant problem and create big hurdles in our campaigns to help individual animals. But yes, it doesn't mean that individuals who work in zoos are necessarily all bad, but I was really speaking to the AZA question, or CAZA, or Mexican zoo associations, or most of them in the world.
I just wanted to say I have some experience with AZA, and it is like a silo system. The keepers and scientists associated with different species seem to have different ethical and educational goals and achievements and values. And so you could talk to somebody, for example, in the primate world, at least those folks are incredibly well educated, whereas people in the elephant world, typically, you're lucky if you're talking to somebody who got their GED. So it's wild how uneven the ranks of professionalism are within AZA. It's not a monolith. I guess that in that way I very much agree with Dulcie, but I also, also agree with Julie that if you do get the attention of the management of AZA, they'll do everything in their power to destroy you and destroy whatever your cause is.
Yes, in LA, good example, we had an advantage in that nobody was paying me, and so we could litigate forever if I did keel over, and they had to pay money. And so that was an advantage that was very swiftly neutralized by the AZA, who brought in experts from all over the world, as we did, and made it a very fully contested case. And their cult-like attitude that any attack on any zoo is an attack on every zoo forces them to fight every case like you might get a spider crack in the china that would cause the entire organization to fall apart just because you won one case. So they are truly the enemy in the sense that they have this gestalt mentality rather than thinking about the animals on an individual location or an individual basis, which is what drives all of us.
They're really a commodity, right, to the zoo? The animal's the commodity. They're specimens. They're money makers, right? Okay, this one's, and if someone could explain, or for those of us like me who don't know, in the wake of the Cricket Hollow decision, do you anticipate a flood of lawsuits based on the USDA's rubber stamping renewals? How do you ensure that the necessary groundwork has been laid prior to suit? What makes a case for a smoking gun with the writings within the meaning of Cricket Hollow? There you go.
I'll take this. So just as some background, because there have been a number of cases against Cricket Hollow, including Endangered Species Act cases, this is about a specific challenge to the USDA's issuance of a license to Cricket Hollow. And the licensing issue is one that I've also been working on for many years. And the gist of it is that the Animal Welfare Act states that you cannot issue a license to someone unless they demonstrate compliance with all of the Animal Welfare Act standards. The USDA has disregarded that for decades, and its policy has been to automatically renew licenses of facilities. And in a lawsuit brought by the Animal Legal Defense Fund challenging the renewal of Cricket Hollow Zoo's license, the DC Circuit ruled that when the agency has information before it at the time of renewal that would make it know or should know that the agency's statement on its application that it's in compliance with the Animal Welfare Act is false and fraudulent, then it would be arbitrary and capricious and unreasonable for the agency to issue the license to the facility. I do not anticipate a flood of litigation in response to this. I will tell you, you can probably see a lawsuit in about a month about this issue. But I think you really need, the smoking gun case is one where you know for a fact that the USDA went out before renewing the license and documented violations, and those exact same violations were persisting after the time the license was renewed, and that does happen in a number of cases. Cricket Hollow Zoo was a particularly strong case on the facts because the agency went out the very day that it renewed the license and documented a host of violations impacting dozens of animals, and those issues persisted. So I think we will see some litigation, and hopefully that will put some pressure on the USDA to follow through on changing its automatic renewal policy. They announced in the fall that they were considering doing that and took public comment on it, but of course have not done anything further. So we'll continue to see movement in this area, but in general, I don't think floodgates and litigation are a real concern because there are a lot of procedural hurdles to bringing litigation, and there are a lot of resource hurdles.
Okay, and this is a new question just handed to me. Given that a take under the Endangered Species Act is Endangered Species Act is more than killing an animal and includes harassment or loss of habitat, are there guidelines for what constitutes a take for animals in captivity?
So, I'm sorry I'm taking all these questions, but these are things I've worked on. The Fish and Wildlife Service has struggled forever with the fact that captivity itself harasses animals in a certain way. And the way that they have chosen to address that is by adopting a regulatory exemption, a regulatory definition of harassment that exempts certain things. Specifically, for our purposes here, it exempts generally accepted husbandry practices that are compliant with the Animal Welfare Act and that are not likely to harm the animal. And all three of those things need to be met. And this regulatory standard has been at the center of a number of lawsuits recently. But the majority of the federal courts that have addressed this issue have recognized that all three of those things need to be met. And also that Animal Welfare Act compliance shouldn't be determined based merely on what the USDA has said, but that the judge has an independent duty to inquire into whether the Animal Welfare Act is being complied with. So that regulatory guidance is what we have. The remaining guidance is going to continue evolving from the case law, from the cases that are currently pending in the courts and will be brought in the future.
Okay, do we have, we've got a couple last questions up here, but does anybody have any questions out there that you didn't want to write? Yes, and can we take a microphone, or can someone bring you a microphone, or should I run out and bring a microphone? I'm happy to do that.
Do this. So my question is, I hear you use the word enemy, and in my heart, there's a fork in the road, because I feel myself with you in that, and I also know that the adversarial mindset is part of why we're in the pickle that we're in. And so I'm wondering, how can the legal system be used to help us make the cultural shift away from adversarial thinking, away from enemy, perpetrator, and all of that? Because I think that's underlying a lot of the dilemma.
I'll say one quick thing about that. I'll just say one quick thing and then I'll pass it back. But so here's the thing. I've been at this 30 years. For the first 10 years of my career, we attempted to work with both the Canadian and US zoo associations to try and get rid of the roadside zoos. We said, let's work together to get rid of the real dregs. No way. That thin edge of the wedge argument, and no matter how kind we were to the accredited zoos, they would not help. And in fact, most recently have been justifying some of the worst situations in roadside zoos that really have nothing to do with them. The truth is, I don't think there's much you can do to bridge that gap personally, except what we're doing by undermining, by changing the way people think about captivity. I can say our elephant campaign in Toronto had an amazing side effect that I hadn't anticipated, and it was partly because the zoo forced us to fight it all in a public way. So there was article after article after article, and we were constant press conferences. But what it caused was, initially, when we started that campaign, media would phone up and they would ask, aren't you really just trying to close down all zoos? Aren't you just really opposed to captivity? Now they phone my ass and they ask me, what is the purpose of even having a zoo? They're asking the right questions, and that has started to turn the industry. So essentially, I guess I'm saying is they have built a fortress around themselves, the zoo associations, I'm saying, and certain individuals within the industry. And the way to break down that fortress, in my opinion, is for the public to no longer accept that and the industry to realize they must change. That's my opinion.
Okay, we're running a little bit behind time, so we'll take 2 more questions from the audience, and then I have another final question. There's a question that someone put in for Carol, but I think Carol's on a panel, so she can do that one because she's not on this panel. So I didn't forget your question.
So I wanted to ask, what legal basis does an aquarium, such as Seaquarium, have to keep an individual orca, such as Lolita, in her tank when she's been included on the endangered species list, specifically her name, with the southern residents that are spotlight endangered species? How does that legally work once they've identified a specific individual and agreed and put their name on the endangered species list? What legal ground do they have to continue to keep them in captivity?
So, yeah, I've been litigating Lolita's case. So Lolita was initially excluded from the Southern Resident Killer Whale listing, and then following efforts by PETA and the Animal Legal Defense Fund, including litigation, was added several years ago, and we brought an Endangered Species Act case against the Seaquarium. And the first simple answer to your question is that the ESA does not prohibit possessing an endangered animal. It says nothing about the mere possession of the animal. You need to show that the animal is being taken, i.e., for these purposes, harmed, harassed, wounded. Of course, you would think that Lolita is absolutely being harmed, harassed, wounded. She has been held without the company of another orca for decades. She's routinely raked by the dolphins she's kept with. She has a eye condition that requires daily medication, on and on and on. Unfortunately, the 11th Circuit has strayed from every other circuit that's reviewed this question about what arises to the level of a take for a captive animal, and has said that you need a serious threat to the animal, a threat of serious injury. That is nowhere in the ESA. It's not supported. It contravenes Supreme Court precedent. Not only that, then they proceeded to say Lolita is not being severely harmed or harassed by her conditions, which without any analysis. So we have asked the 11th Circuit to rehear that issue en banc. That's the entire body of the 11th Circuit, because we only had a 3-judge panel that issued that initial decision. We're waiting to see what happens on that. But the 11th Circuit is an outlier on what you need to show for a captive animal under the ESA. So be careful if you're looking at lawsuits there.
So here's a really interesting question. I'd like to give this up to Eva. How do we get other activists and the public involved with helping to create a movement to help elephants? And this says zoo elephants, but I mean all elephants, because elephants are all over the world. And how, from a legal point of view, from the point of view of people who are working in this sphere, what can we all do, or how can we promote elephant welfare and elephant conservation?
I think I'll be presenting more about that tomorrow, so I will not say much about it. But I was saying that will be what I'll be presenting about tomorrow. But I think for me, context matters, and also appreciating culture matters, like what Carol says, was talking about, because talking from a perspective where Zimbabwe is one of the range countries. Zimbabwe is a country where we have an abundance of these elephants, and Zimbabwe is a country which is actually looking for clients who actually want these elephants to go to the zoos. So if you're able to understand the context, or if you're able to understand the country or the situation where these elephants are, and why the country wants to send out the elephants to the zoos, that way it will be able to give you strategies and ways and means of either educating the source countries, or either showing them that the areas where the elephants are being taken to, the zoos, which is supposed to be desirable and acceptable destinations, are not acceptable, are not desirable as we, or as the people who want these elephants try to portray and try to give us the information. And also just being on the ground. When you're far away from where these elephants are, where there's an abundance of elephants, it's easy to come up with conclusions from a desktop. Go to the ground. Come to Africa, come and see these elephants, come and see the human-wildlife conflicts that are happening, come with solutions. That way, you also deal with the issue of supply and demand. Zimbabwe is looking for places to give out the elephants, to give out to the zoos. I was told, please find clients. So if you understand the situation, if you understand the context of the supplier, then it will be easy to also deal with the issues of demand. But I'll be talking about that tomorrow. Thank you.
So we're just about out of time. And does anybody have any further remarks from the panel? No? Well, I do, because I went to law school. No. My little quick thing is that we have been trained as a society to think that change starts from the top down. And if you look at the top of our country right now, whoo, right? We don't want that change to filter down. But real change and real power goes vertically. It goes horizontally. It doesn't go vertically. So everybody in this room, remember that. We are spreading power and message and education horizontally. things are going to float down from the top, right? Everything's going to come down that's bad, but we are all empowered to move change and new power horizontally. So even in the face of the USDA and really intelligent lawyers and big money and big zoos and the AZA and all of that, the real change will come from us. Okay? And that's it. I think we're done. Thank you, panelists.